C'est donc la dernière table ronde de notre première journée qui va être...
Last roundtable on humanization of private international law and the leadership of Professor Anna Buxbaum, which is a member of the curriculum. She's going to introduce the panel so that he can be as interesting as promised. Dear Anna, it's all yours.
Good afternoon, and thank you so much to all of you who have persisted.
Merci et bravo d'avoir tenu bon jusqu'à cette dernière séance sur
international law. So it has been a very full day, and I am planning to moderate this panel in the ruthless American style, which means sitting close enough to the lectern to physically intervene if necessary, no matter how eminent the speakers. And we do have a panel of very eminent speakers today. We will start with Judge and Professor Emeritus Fausto Pocar, who is going to provide an overview of this topic, asking whether a human-centered approach can engender a reconstruction of private international law to advance not only substantive interests within private relationships, but also global public interests. So he will begin, and then I will introduce each of our four speakers in turn. So, Professor Pocar, the floor is yours.
Monsieur le Président de l'Académie,
President of the Academy, my dear colleagues, ladies and gentlemen, this morning, after I'd listened to Yuko Nishitani and Horatia Moore-Watt, I was actually almost going to give up with my overview because I thought it's a little bit too much, really. It's a little bit too much. But then, of course, I looked at the program carefully. And the program, at least in the French version, it says that it talks about public international law, and it says humanization of, it still said public international law. But I think that there was an article that was forgotten. Here we're talking about the humanization of private international law with no definite article in front, whereas the previous had a definite article. I think in French you might actually expect an exclamation mark. How come there's no definitive article? How come? If you forget the definite article at the beginning of such a title, what's happened? And that, if you like, is my point of departure. That's where I'm going to take this from. Private international law, ultimately, can it actually meet international interests that we have at the moment? And I'm now going to switch over to English because my notes are in English. And English is also shorter, so I'm told at least. So maybe, I'll keep it a little bit shorter. Thank you.
Alors, can private international law contribute to satisfy international public interests, including those underlying the achievement of some, if not all, the Sustainable Development Goals contained in the 2030 Agenda of the United Nations? The agenda was mentioned in the first title of this panel, then was abandoned for the humanization. But it's still there because I assume that the public international interests are included in that agenda to a large extent. So the question is not black and white. Bearing in mind that private international law has been traditionally construed how it's been construed in legal doctrine. Although private international law appeared to have a vocal dimension to deal with global international life and problems, because a significant part of the rules of private international law has a universal application in the sense that they are inclusive of the laws of all the world. They refer to different laws, so to all the words are included in private international law. But the legal approach was traditionally to attribute to these rules a neutral nature, instrumental to the identification of the law applicable to private relationships or situations, rather than in their substantive regulation. It's the law applicable that decides on the regulation of the situation or relationship. So private international law was considered not very fit for taking into account interests protected by substantive law. It just should be neutral, find the law, and that's it. And then the law will protect the interests. It's not private international law that should do that. This traditional construction of private international law has been later challenged and partly set aside in favor of the recognition that its rules may also reflect a consideration of substantive interests, which deserve special protection, in particular in private relationship when the individuals concerned are not enjoying an equivalent position in the society, but they have a contractual relationship, for instance. And the view was to balance their position by allowing the weaker party, both in contractual and tort relations, to avail themselves of special connecting factors, or to choose the applicable law, or the court before which their reasons could be heard. So in light of this, should we still come to the conclusion that private international law is unfit for contribution to face the new challenges that arise from the need to protect global public interests? Because if we remain in the private domain, we can understand changing the structure of private international law a bit. One can easily come to substantive interests. But these are public interests under international law also. And I don't go into the definition of public interest. This morning we heard an excellent panel and Judge Nolte giving an interpretation of the international interest. So the global dimension of these new challenges may at first suggest a negative answer, and it may be difficult to resist the temptation to propose a radical and revolutionary approach to private international law. And we have heard, in fact, this morning, one excellent presentation invoking a complete restructuring of private international law, as if the current mechanisms, the current tools were not sufficient for protecting interests. But I try to resist that temptation, because bearing in mind that adopting a better approach than restarting from the scratch and entirely revisiting the categories, the mechanisms of the discipline has proved to be able to reach important goals would mean losing something, probably. But it should be remembered also that one cannot ask private international law to resolve all the problems raised by an emerging new challenge, but only to bring a contribution to the solution of the challenge, as far as conflicting laws may be applicable and conflicting jurisdiction may be competent to adjudicate disputes having impact on the issues raised by such challenges and the protection of the global public interests that they require. So I passed to see which are the causes of these new elements that would require a change in private international law, and which are how the tools could be used in light of these causes. Now, the main cause, essentially, to be considered is, in my view, is the overbearing entry into the legal debate of human rights. And this also includes the more recent developments that have introduced into the legal debate the protection of the environment, including even more recently the consequences of human activities on the current climate change. And Professor Nishitani has mentioned all these aspects that are all related to the human rights dimension, in fact. Why are these related to human rights? Certainly if the protection of the environment is regarded from an anthropocentric perspective. But this has a human rights connection even when the protection of the natural environment is considered objectively as referring to the ecosystems as such and to any form of life on the earth. So can the usual tools, the traditional tools of private international law play a role to take into account interests which are not private interests but public interests of the emerging in the international community as a whole? First, the connecting factors. The connecting factors are the basis of private international law, inevitably. And there are two different issues there. On one hand is how to adjust to human rights values the connecting factors with the applicable law and with the competent jurisdiction in order to prevent these connecting factors themselves to be in contrast with a human rights requirement. For instance, you have in a family, the spouses, you can't say the law of one prevails over the other. This is clearly against the human rights requirement to keep an equal treatment of the person. But on the other hand, how to ensure, and that's more difficult, that the result of the application of conflict of law rules does not bring about a substantive violation of human rights law. This is more complicated, in fact, but all these issues need to be, 2 minutes, need to be resolved because one aiming at ensuring conflict of laws justice, the other point is a substantive law justice. I will skip on public policy and overriding mandatory positions and come to what I think should be done. In terms of connecting factors, the only solution I see to take into account of substantive interests is to base the reasoning on the better law approach. You may have this go also for corporations. There's been talked of corporations this morning. Corporations are chains in which each of the corporations in the chain plays a role, but there is always a leader. And each corporation has a different law. The leader normally uses the different places to apply the laws, the different laws that have less protection. Now, if one takes the approach that all the connections come into considerations, and the better one applies, the problem remains to see which is the better one. And the better one, in my view, should be the one that satisfies better or contributes better to satisfying these international interests. This creates a problem, of course, of connection between public international law, private international law, but it's something that should be explored. I don't have the time to go more in detail, but of course my text is available, so it will be available later on. So I ask you to look at that if you are interested. Thanks.
Thank you so much. So we will now have 4 speakers exploring the question of humanization within specific areas of private international law. And the first is Burkhard Hess. So please. So Burkhard is director of the Max Planck Institute Luxembourg for International, European, and Regulatory Procedural Law. and he will explore the shift in civil justice systems from an approach focused on a state's protection of domestic parties only to an approach securing procedural fairness to all parties. Thanks.
Thank you very much. I would like to thank for this invitation to a place where I have spent very nice times of my life, several occasions, and I'm very honored and pleased to meet here so many colleagues and friends at such a moment. So when I got the topic of my presentation, I was a little puzzled. I was asking, do we have a similar paradigm shift in private international law with regard to humanization as we have seen it in public international law? And my first reaction was, no. Private international law always looks at the individual, so there is no need to move from the state to the individual. The individual was already there. But this is too simple. There are state interests in private international law, and in order to see how the situation has changed, I would like to go back 60 years and to look at international civil procedural law 60 years ago, just to demonstrate to you how big the changes are. And then we can also see whether human rights are one of the main driver of changes. So let's go back 60 years. And if we look at jurisdiction, there were heads of jurisdictions in different countries, continental law, common law. In continental law, there were heads of jurisdiction based on the nationality of the plaintiff, just to protect the domestic plaintiff not to bring actions abroad. There were heads of jurisdiction based on assets, but if a tourist lost an umbrella at the hotel, he could be sued because the umbrella was considered an asset. So this was one-sided, and tax jurisdiction in common law countries was also simply based on the presence of the defendant in the court's district. A foreign plaintiff needed to provide a security. Why? Because the defendant, in case the case would be lost by the plaintiff, should not be forced to bring again a new lawsuit for litigation costs abroad. Again, an impediment which was unfair to the foreign defendant. And when it came to the recognition and enforcement of judgments, reciprocity was the basic approach. It was not about the right and interest of the private party, but it was about getting an international bilateral system of enforcing judgments, and if reciprocity did not exist, the private creditor, the foreign party, the foreign creditor, could bring a new claim in the requested jurisdiction, which means double cost, double time, double risk. So, has it changed in the meantime? Yes, it has. And the first trigger was at the regional level, the Brussels Convention. The Brussels Convention provided for a so-called double convention. So there are uniform heads of jurisdiction. There is a simplified system of recognition and enforcement of foreign judgments. And this international approach looks at both parties at the same time, interests of both parties. There is an equilibrium which is now or was achieved. But you don't have any reference to human rights in the Brussels Convention. This was not the perspective. The perspective was regional integration. Civil litigation, civil procedure was considered as being a part of a larger framework facilitating cross-border exchanges of persons, services, goods, etc. So the big driver was regional market integration. And if we look a little bit broader, I'm focusing here a little bit on Europe, but I have done a research in a parallel project which is a global one, and one can see that regionalism is not only a European situation. This is the situation of the world of today. We have to be aware. We have regional systems of human rights protection, and we have regional systems of economic integration. And they go a little bit in parallel. And this has consequences. So in Europe, the old idea that the foreigner had to bring security for litigation costs was abolished by a judgment of the European Court of Justice saying discrimination by nationality does not work within the internal market. And it was an outcry for the community of proceduralists reading this judgment of the court from Luxembourg. But it was a real eye-opener, and it changed the systems within the internal market considerably. We now have much fairer civil procedural laws regarding cross-border litigation. But, ladies and gentlemen, only to some extent. Now we have the situation of inside and outside with regard to the regional systems. So just take the European Union. We have an integrated system within the European Union, but for the foreign plaintiff from outside, it's still difficult, it's still possible to get security for litigation costs. This is now a big issue after Brexit for parties coming from the UK. And the question is this a good outcome? And I think here, and this we have also experienced, human rights come in. So the human rights perspective also applies to third state parties. And this is a big challenge, and I would say also an unachieved result so far. There is a very interesting resolution of the Institut de Droit International, which was finalized in 2021 about human rights and private international law. And I'm speaking here under the control of Fausto Pocar, who took over from Jürgen Basedow, our late colleague we miss a lot. And this is an interesting state of affairs declaration, which clearly states that human rights are important in this area of law. But on the other hand, it's also a cautious one, because it took the global perspective, I come back to this in a moment, as a starting point, not so much the regional perspective, which was more present in the original proposals of Jürgen Basedow. And just to give you one example, does a creditor who disposes of a judgment has a right to recognition and enforcement of this judgment in other states? Do we have a human right in this regard? If you look at the case law of the Strasbourg Court, it's quite clear. Access to justice under Article 6 of the Convention comprises enforcement too, and cross-border situations too. But at the global level, if one looks at the resolution of the Institut de Droit International, there is only an invitation, an encouragement of states to ratify international conventions on the recognition and enforcement of foreign judgments. So, where do we stand at the moment? Well, we have the 2019 Hague Judgments Convention, which shall facilitate the recognition and enforcement of foreign judgment at a global level. This is a very valuable project. But there is, of course, the old problem we are facing since many, many times. Conventions need ratifications. Ratifications are, let me be very open, unsatisfactory at the moment. We have the European Union, okay, 27 member states, and the Ukraine. That's all. So the situation at the global level is not as it should be. What could be done? And here I have a proposal. I think we should not only go for conventions. We should take up something which has been emerged more and more often in international organizations. We should go for model laws, best practices, and to my opinion, the resolution of the Institut de Droit International would be a very good starting point to go in more detail to look at the situation of the party coming from a third state and the human rights protection which is necessary as a minimum standard in different states. And we could encourage states to adopt these rules in order to improve a situation which, to my opinion, still needs improvement. The rest of my thoughts, you will find them in my paper. Thank you very much.
Thank you, Burkhard. Our next speaker will be Katharina Boele-Woelki, president of the Bucerius Law School and my colleague on the curatorium. She will discuss the impact of developments in human rights in the particular area of family law. Thank you.
Thank you, Madam Chair, dear colleagues and friends, ladies and gentlemen. My contribution on the impact of human rights on private international law, in that contribution I examine the question which conflict rules are most appropriate for two areas. First, cross-border de facto relationships of couples who are neither married nor registered, and second, gender identity, in particular non-binary gender recognition, including also transsexuality. The substantive law regulations in both areas currently in place are not yet settled. The discussions on whether and how de facto unions should be regulated by statutory law, as well as the many recent draft laws on self-determination regarding gender, show that more changes in substantive law are to be expected. Hence, the debate on how the approach to private international should also be shaped is ongoing. I focus on the importance of human rights for the formation of conflict rules in the field of family relations. Is their significance limited primarily to the specification of principles so that human rights are only a meta-order that provides a framework but leaves the details to the norm makers? Or does the human rights framework go beyond this role? First of all, and rightly so, none of the human rights systems is specific about what kind of family it wishes to protect. Had these human rights systems provided a definition, then society's understanding of what constitutes a family, which has evolved over time, would not have led to the corresponding protection of family life through human rights. In the inter-American context, for example, it has been argued that its human rights system has, from its inception, had an expansive notion of equality and non-discrimination, which today includes the family rights of non-heterosexual and gender non-conforming persons. And the same understanding has been confirmed for the European human rights framework. What is the specific impact of human rights on particular conflict rules, and in particular, how have these rules of applicable law been adapted over time in relation to cross-border relationships? In answering these general questions, some legal theoretical considerations are important. In my view, three major developments can be identified. First, the shift from the nationality as a connecting factor to the habitual residence of a person, and in addition, the balanced use of the two connecting factors combined with the non-discrimination of gender. Second, the result-oriented formulation of conflict rules in certain areas. This development is based on the consideration that a more favorable result should be achieved for the parties concerned, so that more than one jurisdiction with which the relationship is connected may be applied in order to achieve the desired result. For instance, for the partners to marry, for divorce to be granted, for maintenance to be obtained, or for parenthood to be established. Third, the possibility for individuals to choose the applicable law within certain limits. Today, based on human rights, personal responsibility and self-determination are the key words that justify the ever-expanding possibilities of choosing the applicable law in international family law. Taken together, these three features show that the impact of human rights on international family law has grown considerably. Human rights guarantees have been taken into account in the formulation of conflict rules by international and regional organizations and national legislators. And with the progressive concretization of human rights objectives, not least through the jurisprudence of supranational courts, the question of the need to adapt and optimize the thematically linked conflict rules arises again and again. This is the general context which in the following will be applied to de facto relationships and gender identity, two areas which, due to differences in substantive law, affect cross-border situations. In order to be able to propose the most appropriate conflict rule in each area, it's necessary to have a comparative overview of both the substantive law and, as far as available, the existing conflict of law rules. I will not have time for this. But it will not come as a surprise to those familiar with comparative family law, particularly in the two selected areas, that the differences in substantive law between the jurisdictions are enormous. At present, regarding de facto unions, we are witnessing a wide disparity from full legal recognition to no recognition or a partial recognition of the relationship, which in turn explains why, firstly, there are a few jurisdictions with explicit conflict rules, and secondly, there's also more diversity than uniformity as regards the choice of objective and subjective connecting factors, but also and above all as regards the absence of any conflict rules on de facto partnerships. And the same applies to issues of gender identity. A positive gender marker beyond the categories of male or female is legally possible in only a few countries. And in early 2023, the European Court of Human Rights ruled that the French authorities had not violated the applicant's right to respect for private life by refusing to replace the word male on the birth certificate with neutral or intersex. However, despite the many jurisdictions that will maintain the binary system, the emerging international trend since about a decade is to move towards the third option, which is one of the recent achievements of civil status law. Hence, the question of the legal recognition of a non-binary gender has been high on the agenda internationally, but also in many national jurisdictions. And in this context, Target 16.9 of the UN Sustainable Development Goals 2030, which promises to realize the fundamental right of everyone to recognition as a person before the law, is also relevant, as legal identity is much broader than birth registration. It includes all aspects of one's personal status, age, name, gender, marital status, etc., and requires not only the registration of all major life events, but also their certification. Given the significant differences between national legal systems, the question arises as to how to resolve cross-border gender identity situations. In countries, for example, where the opposite sex of the spouses is required at the time of marriage, the recognition of the gender identity of a trans person is still relevant. In addition, the question of gender identity is also conceivable as the main issue of conflict of laws in the initial registration of civil status, for example, in the case of the birth of intersex children with foreign nationality. However, there are only very few jurisdictions which address cross-border gender identity issues. The first question to be answered is how to classify gender. Does it belong to the category of legal personality and capacity, or is it a specific category that is distinct therefrom? My search for the most appropriate conflict rules on both de facto unions and gender identity in the context of the humanization of private international law revealed the following. First, the impact of human rights on the substantive law of the respective areas is predominant. In particular, in the area of legal gender recognition, constitutional courts and regional human rights courts have often ruled that national law has violated the respective human rights framework. For both areas, de facto partnership and gender identity, I propose to use the habitual residence of the person concerned as the predominant and decisive connecting factor. And this is not surprising for de facto partnership, as it puts this relationship in the same category as marriage and registered partnership. It is consistent from a human rights perspective. Classifying de facto partnership as a contractual relationship, as proposed by some German scholars, fails to my mind to recognize the true nature of such a relationship in which two adults live or have lived together as a couple in an enduring relationship. The subjection of gender identity to the law of habitual residence is revolutionary in nature, as these issues have traditionally been thought of in terms of personal status, which is usually governed by the law of the country of origin. Here, the human rights influence should have the effect that all persons are treated equally, regardless of their nationality. And since party autonomy has gained importance in international family law, it should also play a role in de facto partnership, and this should be equal to what is possible for spouses and registered partners. The same applies to issues of gender identity, when the person concerned might obtain a more favorable result under their national law than under the law of the habitual residence. The human rights framework should thus not be limited, as questions at the beginning of my intervention, to the definition of principles, but also specifies the selection of relevant connecting factors and prescribes these for the norm maker. In conclusion, the humanization of private international law has taken place, but the ultimate goal of equality for all, self-determination for all, and the recognition of family forms other than marriage and registered partnership has not achieved everywhere in the world. Private international law remains called upon to fill the gap. Thank you.
Thanks, Katharina. We will now turn to Géraldine Escolar, Deputy Secretary General of the Hague Conference on Private International Law, who will survey the view from that organization in the context of its work program. Thank you.
Thank you very much, Madam Chair. Monsieur le Président du Curatorium, Monsieur le
President of the Curatorium, Secretary General, Excellencies, dear friends.
What I have to say in the 9 minutes that I have. We celebrate today the centenary of the Hague Academy. And let's take a moment, I have 9 minutes, but take 10 seconds to say, wow, what are we celebrating? Millennia of human experience and expertise in international law. That's what we're talking about today. Thank you for having me speak with you today. I learned international law at the knees of a lot of these wonderful experts, the luminaries that spoke before me today. And it's wonderful to be back here in this room to meet with these teachers and these mentors that I've had throughout my career. Now, the Hague Conference on Private International Law, despite its name, is an international intergovernmental organization established by treaty to work for the progressive unification of the rules of private international law. Now, we interpret that term quite widely. It concerns primarily, of course, conflict of laws, which also includes not only applicable law and choice of law, but also jurisdiction over cases with an international element and the recognition and enforcement of judgments. We add to that traditional list of 3 mechanisms of international cooperation, seeking the most direct, efficient, and effective mechanisms to give quotidien cross-border matters easily resolution. Now, the usage of the term private international law originated from the French term droit international privé, which, as Batifor and Lagarde define, consists of, and I quote, the totality of the rules applicable only to private persons in the relations of international society. But we heard from Professor Nishitani this morning that localizing cross-border relations in the state with the closest relationship in international society just doesn't cut it anymore. There is no longer as she kind of very nicely put forward, value-neutral allocation of state jurisdiction. What does this mean? On this day in 1889, 134 years ago, exactly today, was born Igor Sikorsky. He's known as the inventor of the helicopter. Why is that important? Because the helicopter humanized flight. You get into this machine, it rises from the ground and sets you down someplace else and creates an air bridge. And that's what private international law at the Hague Conference does. It creates bridges between different jurisdictions in different states. Now, at its heart then, as conceptualized, private international law is conceptualized, concretized, and constructed at the level of humans. I just had coffee with Hans van Loon, and you will hear from my former Secretary General before, and he mentioned to me, as the great Adair Dyer has said, the HCCH is a human organization. Now, we were mentioned, of course, just a little earlier by Professor Hess, that it's a little too simplistic to just look at it that way. And so what shall we look at? Now, the Hague Conference is 130 years old, from 1893. And so looking back on this centenary, we have 130 years to look on. In 1923, when this academy was founded, there were 7 Hague Conventions. We call them now the Old Conventions. But they deal with human relationships. In 1902 with marriage, divorce, guardianship for minors, and the effects of marriage, and then going on to civil rights and procedure. I won't have time to go into them, but it's quite important that we look at this from this perspective. In the time remaining to me, I just want to talk about 3 things which really deal with the humanization of private international law. The first is the protection of the building blocks of human society, individuals and families. The second is the concretization of access to justice. And the third really is breaking the poverty cycle. Now walk with me through this. The first one is family law and child protection, which really protects the building blocks of society today. And when we talk about that, we talk about humans, human units, and as you heard from Philippe Sands earlier today, humans as individuals and as a member of a group. The Hague Conference has contributed towards private international law notions from nationality via domicile to habitual residence. We look at now the best interests of the child. The first actual convention already from 1902 for the guardianship of children, and really look at that as the paramount interest of children. We also protect our society's most vulnerable, and we've heard that the protection of our most vulnerable is what says the most about our society. Now imagine you have a baby and her name is, let's call her Sophia. Now Sophia is born in a place where her birth family might have some trouble taking care of her. Her best interests are still paramount. And so the paramount means in that situation that there's a subsidiarity principle, that adoption shouldn't be put up unless the birth family or the extended family cannot take care of that child. Barring that there is no family in the state of her origin that can also take care of her, and then perhaps there is intercountry adoption. The 1993 intercountry adoption considers all of this to protect the best interests of Sophia. Now, we can go on, of course, about various different things, but there is now further contribution to this, and the Hague Conference, of course, has other conventions, and to further contribute to humanization, we also have the protection of women and children. And here, an example will be the 1980 Child Abduction Convention. When that convention was negotiated more than 40 years ago, the idea was that most of the taking parents would be taking fathers. 40 years on, we found the statistics to be the direct opposite. Now, nearly 75% of parents who have taken their children, according to the definition of this convention, are taking mothers. And this is something that we need to address when we talk about the humanization of the impact of this convention. The same convention has Article 13.1, paragraph B, which we have just published a guide to good practice on. And also following on Professor Hess's intervention, is not just conventions, but really talking about best practices, good practices, on how to interpret and properly implement those conventions. Very soon, in October of this year, we'll go to the meeting of the Special Commission. And there, one of the things we'll discuss is under Article 13, paragraph 2, which is about hearing the voice of the child in relation to whether that child should or should not be returned. Now, that's a circle. So this is really a circle of the life that we have as children, to become, some of us parents, to have our own children, and that's a circle, the humanization of private international law. Now, moving quickly on then to concretizing access to justice, that's really transnational litigation, and the shape there is an arc. So when we're talking about civil procedure, for example, Professor Hess has already spoken about it, and you will have to, I'm afraid, read about civil procedure. But the Hague Conference has basically given concretized impact to improving notice given to defendants with the 1965 Service Convention, curbing excessive discovery practices with the 1970 Evidence Convention, giving parties autonomy in the choice of forum with the 2005 Choice of Court Convention, and then at the end of the arc, giving effect to resolutions. And that's the 2019 Judgments Convention, which was finally negotiated in this very room, finalized here, and then right across the way signed in the Great Hall of Justice on the 2nd of July in 2019. And that allows the recognition and enforcement of civil and commercial judgments across borders. Now, as we look at these things, what do we do going forward? We now look at jurisdiction and parallel proceedings. And in a book which Hans van Loon has edited, among others, there are connections between harmonized rules to reduce the risk of parallel litigation in different states, which will be important for international businesses, including those in the agri-food sector. So there's all these links to humans and their basic needs. Of course, transnational litigation also contributes to the rule of law, which is peace, justice, and strong institutions, the oft-quoted SDG 16. And that arc is the arc of transnational litigation. Now, quite quickly, and the last one is the triangle, which is commercial, digital, and financial law. Now, one of the very first sessions, the first 4 sessions of the Hague Conference was chaired by, Tobias Asa. Now, we heard so much about Tobias Asa, so I won't go on about it. But he had chaired the conference's first 4 sessions, focusing interestingly on bankruptcy and other types of commercial matters. There was a lull in the work, and I don't think that it is a coincidence that after the establishment of the Academy, and as we heard, the PCIJ, in 1925, the work of the Hague Conference picked up again. And of course, we started looking at facilitating trade and commerce together with our sister organizations, UNCITRAL, the United Nations Commission on International Trade Law, and UNIDROIT, the International Institute for the Unification of Private Law. Now, there we look at facilitating trade and commerce through party autonomy and the international sales of goods, negotiable instruments, secure transactions, and what's most interestingly, the idea of broaching through different legal traditions with the 1985 Trusts Convention. I was trained in the common law, but if you put 25 common law lawyers in a room and ask them what a trust is, you're going to get 50 different answers. But still, it is something that, while might be slightly foreign to a civil law tradition or even to an Islamic law tradition, we found ways to bridge that gap. And we see that in the digital law world, this might come up again as something important in regulating private international law relating to decentralized autonomous organizations. Now, the Hague Conference now has a mandate for 2 more projects, the first one on central bank digital currencies, and the second on digital assets and transactions. And what's important to this is that these projects contribute to financial inclusion. Now, 8 of the 17 UN SDGs refer to financial inclusion. And why is this so important? Because when we have access to finance and access to credit across borders, the capital flows across border allows us to then break that poverty cycle, and that's SDG 1. So when we look really at the contributions of private international law to international trade and commerce, to business transactions across borders, we're really looking at the autonomy of parties to have transactions between them. Remember Sophia? So she was adopted across the border, grew up, and wanted to study somewhere else. She wanted to legalize the documents, and with the Apostille Convention, got it done just like this, went across the border and decided to start a business there. The access to credit and financing was allowed through different arrangements with private international law, and this is how, for Sophia and for every Sophia around the world that we might know, and those Sophias that they might know, we humanize private international law. We protect the weaker parties, and we make sure that we protect the building blocks of our society. The current estimate is 281 million people living outside the borders of their country of nationality or origin. There are 5 billion people online and 1 billion unbanked people. When we're talking about financial inclusion, when we're talking about party autonomy, when we're talking about protection of weaker parties, we're speaking of these people. So, as we go forward, and we heard earlier yesterday from Peter Truboff about ChatGPT and artificial intelligence, I think when we talk about private international law, we need to ask, what does it mean to be human? What are the values we are protecting? And when we say we're humanizing private international law, at the base of it, which values are we trying to protect? And I think it's very important, of course, as Professor Pocar said, that we do not violate substantive law, substantive human rights in private international law, but it's really also important that we go forward building on that block of society. On this day in 1977, 46 years ago, the first Star Wars movie premiered. And so, 100 years of the Academy, and I wish you, may all the good luck in the world be with you, and may the Force be with you for the next at least 100 years. I thank you very much.
Thank you. And our final speaker is Hans van Loon, former Secretary General of the Hague Conference, who will examine the implicit but nevertheless critical role of private international law in the UN's Sustainable Development Framework.
Merci beaucoup. Monsieur le Président, Monsieur le Secrétaire Général, Excellences, Mesdames et Messieurs, chers amis.
Secretary General, Excellencies, dear friends, now I'm fully aware of the fact that I'm the very last speaker, and allow me, as the former Secretary General of the International Conference of The Hague, to stress the ties between the Academy and the conference, which date back to when the Academy was created. It was stressed that Tobias Asser was totally in favor of the setting up of the Academy. And since then, many scholars and experts have been invited to take part in the courses offered at the Academy, and we're absolutely delighted about this link. We're deeply thankful, and we in fact extend our best wishes to the Academy for its second century.
The General Assembly of the United Nations unanimously adopted the resolution transforming our world, the 2030 Agenda for Sustainable Development, following the adoption of the agenda, again unanimously by heads of states in New York. The agenda, a plan of action for people, planet, prosperity, with 17 Sustainable Development Goals, mentioned already by other panel's members, came into force on the 1st of January 2016. So this year, 2023, marks the halfway point to the achievement of the Sustainable Development Goals, the SDGs. And in September, the General Assembly of the UN will assess where the world stands in relation to their realization and the challenges ahead. And in many respects, that will be the moment of truth. The SDGs go beyond the Millennium Goals, Millennium Development Goals, which covered the period 2000-2015, and they focused on issues of particular importance to developing countries, including extreme poverty, and they had some success. By contrast, the SDGs have a dual nature. Yes, they continue to pursue the goal of development, but they also aim at achieving sustainability, defined by the Brundtland Report 1987, meeting the needs of the present without compromising the ability of future generations to meet their own needs. And this gives the Agenda 2030 a more universal character, as sustainability is an all-encompassing issue that concerns both the global south and the global north, present generations, future generations, us humans, and the rest of nature. But this dual nature of the SDGs also conceals a dilemma. How can economic growth, as a condition to eradicate poverty, improving education and health, and so on, how can that be reconciled with respect for ecosystems and indeed for Mother Earth? This is, of course, a general issue. It's also before the European Union with its Green Deal and indeed national policies across the world. Now, it is becoming clear by the day that rising global temperatures and biodiversity loss affect us all, albeit very unevenly. Preserving the planet, including the livelihoods of now hundreds of millions of people in vulnerable areas, appeals to the responsibility of us all. So the 2030 Agenda not only appeals to public bodies such as states and international institutions and local authorities and indigenous peoples whose relationship to nature can also inspire a rethinking of fundamental notions of law to escape from the motherland, as Horacio Miyamoto reminded us this morning. The agenda also expressly appeals to civil society, business and the private sector, the scientific and academic community, and all people. Now, the SDGs are based on a goal-setting strategy, not on traditional rule-making approach, which perhaps explains why they have not drawn the attention of international lawyers, both public and private, that they deserve. Nevertheless, in many respects, they depend for their attainment on the role, indeed the rule of law. But what is so striking is that while the agenda refers to instruments and institutions in the field of public international law, there is a complete absence of any explicit, at least, reference to the role of private and private international law. And yet, as we know, most transactions, most investments, most destruction of the environment, most greenhouse gas emissions are a matter of private activity governed primarily by private and commercial law, and in the growing number of cross-border cases by private international law. And where the SDGs themselves call for the elimination of forced marriage or urge the transfer of environmentally sound technologies to developing countries on favorable terms as mutually agreed, or insist on the eradication of forced labor and child trafficking, or appeal to ensure equal access to justice for all, private relationships, private law, private international law are at stake. So what is then the role and potential role of private international law in achieving the SDGs? Well, despite the lack of an explicit reference to it, implicitly, I think, the SDGs remind us, and both public and private international lawyers, that private international law is not simply a technical, formal discipline with no policy or regulatory role or potential. In fact, it plays an important role as an instrument of global governance, as Yuko Nishitani reminded us this morning and Fausto Pocar a moment ago. This governance role of private international law has become quite manifest at regional level. In the European Union, it has become a strategy, one of the strategies, to achieve the aims of the Union. An example, the Treaty on the Functioning of the EU provides as a public policy norm, Article 174, that there should be in the Union a high level of environmental protection. Now, the Brussels I and Rome II regulations, both instruments on private international law, give nuts and bolts to this norm. They facilitate access to justice to victims of environmental damage by offering them customized choices, both regarding the court to go to and the law to apply. And in the context of regional protection of human rights, you see that the Strasbourg Court now often considers the role of private international law in its interpretation of the European Convention, Article 6, 8, 14, and the same goes for the Inter-American Court of Human Rights. However, at the global level, public and private international law continue to a large extent to live apart together. And yet more awareness of how they complement each other would reinforce the rule of law in the attainment of the SDGs. Let's take again the example of environment and climate change, core topics of the agenda. The UN Convention on the Law of the Sea, UNCLOS, to which many references were already made, has been described as the international basis upon which to pursue the protection and sustainable development of the marine and coastal environment and its resources. However, its dispute settlement procedures are essentially written for states. The Convention does not provide access to justice and remedies for example, local communities who are suffering harm on the marine space caused by the activities of foreign companies. And yet, enabling such communities to act before the courts, both local courts and ITLOS, could contribute bottom-up to reaching UNCLOS's aims. The same goes for the 1992 UN Conventions on climate change and biological diversity. Yes, in contrast to UNCLOS, the Biodiversity Convention expressly recognizes the presence of local communities and calls on states to support them, but the Convention does not itself provide a mechanism for such action. Now, interestingly, despite a lack of provisions of litigation in treaties, in practice, private parties increasingly succeed in using private law and private international law to assert their rights in environmental and climate change cases. Recent examples include the Vedanta case in the UK, the Agenda case here in the Netherlands, Shell case, and in Germany, the Luya versus RWE case. But then we have the 2019 Convention on Recognition and Enforcement of Judgments, and that convention, in the negotiation of that convention, the environmental matters played only a minor role. So as a result, I'm afraid that convention will not be a great help in environmental litigation, and we need, in my view, a comprehensive new treaty on environmental damage with rules on jurisdiction, applicable law, and enforcement of judgments. That can be done, and the SDGs could be a source of inspiration for both. I would have liked to say something on party autonomy, and that's also very important. I think there are good reasons to reflect further on its role and the limits that we should perhaps apply to them and rethink public policy and mandatory rules. But I will not do that. I'll come to the end. I think that practicing lawyers, including corporate lawyers, including in-house lawyers, will need to become increasingly aware of the negative social and environmental externalities of their work, their contractual work in particular. And private international scholarship will have to look more deeply into the traditional mechanisms such as public policy and party autonomy also. So in conclusion, although the drafters of the UN 2030 agenda may have underestimated the role of private international law in achieving the SDGs, a closer look reveals the role it plays beneath the surface and its potential to play an even more important role as a humanizing force. And that calls for a greater awareness among practitioners and academics alike of the practical impact of private international law on the achievement of the agenda, after all, the only global agenda we have. And it invites a more sensitive mindset to its regulatory effects and potential. And it also calls for creative legal thinking to make private international law even more fit for purpose in addressing the enormous global challenges before and ahead of us. Thank you very much.
Thank you very much, and I'm very grateful for the incredibly interesting substantive content of all of these presentations, but also the concise presentation, which leaves a little bit of time for questions if there is an appetite for that among the audience. And I see Yuko Nishitani over here with a question.
Thank you very much for the fascinating panel. I do have a question. May I ask two questions, just briefly, or shall I go one?
Sure.
Yeah. Okay. Thank you. So one question to Professor Burkhard Hess. You talked about the possibility of using model laws and non-binding instruments. So for the purpose of recognition and enforcement of foreign judgments, the problem we have in Asia is virtually reciprocity. So China and Japan say mutually there is no reciprocity, so that's why there is no judgments recognition between us, and there are Indonesia and Vietnam who accept only reciprocity based on treaty. So within that framework, I'm wondering whether model law can be helpful, or should we expect that treaty can be signed and we can join? I have another question to Professor Katharina Boele-Woelki. You recommended that we apply the law of habitual residence for gender identity. So I'm wondering what will happen if the person changes habitual residence, which can happen quite often. So for the purpose of continuity of the status, I'm wondering whether perhaps using some kind of recognition principle may mediate the problem that status changes across the borders. And I know it's controversial in Europe, but I'd be grateful to know your view about that. Thank you.
Yeah, thanks for this question. Reciprocity is one of the big impediments to the recognition and enforcement of foreign judgments. And one has to try to overcome the mindset behind it. And maybe there are different mindsets in different Asian countries. But the idea of having a model law which gives some basic guidance how to recognize foreign judgments, grounds for non-recognitions, but also good practices might be a first step to change. And this is a little bit my idea. It is a big step for states to ratify conventions. And we can see it especially with the 2019 convention, where even an inner reciprocity mechanism has been implemented. So a bilateralization mechanism. And I simply believe that departing a little bit from the traditional convention approach, which already has been made within the Hague conference, I'm well aware, but even outside of existing instruments might be a good and different approach just to encourage states and also stakeholders in the states, political, economic stakeholders, to change existing habits. And this has been quite successful within HCCH with the different model laws, arbitration, for instance, insolvency. It is also quite successful now with the new UNITROR ELI European rules on civil procedure, which are gaining more and more influence. And therefore, I would recommend to try this approach also in this very difficult area of law.
I apologize, Professor. Without taking anything away from what Professor Hess has just said, it'd be nice also to have a bit of optimism here. We do have news that the 2019 Judgments Convention might get some more ratifications. And in fact, it will come into force on the 1st of September this year, about 4 years or so after it was concluded, half the time it usually takes for a treaty to come into force. So without taking away from this, I do acknowledge the importance, of course, of model laws and other kinds of legislative guidance. But we do also have then news in the pipeline that perhaps this convention will see more ratifications. I just want to add to that. Thanks very much.
Thank you for your question, Yuko. In private international law, we distinguish jurisdiction, applicable law, recognition, and enforcement. We know all these three questions. And of course, the applicable law that I propose is to be supplemented with, on the one side, jurisdiction rules, and on the other side, recognition rules. And a change of habitual residence does not necessarily lead to a change of gender, but the gender obtained in one country should be recognized in the other.
I believe there's one further question here.
Irina Mutai, Kiel University. Really, last 20 years, I have observed a massive degradation of judiciary in Russia. And now it's much more serious because they enact anti-human law and then the courts enforced it. And it's very complicated now. I work with arbitration mostly, but anyway, I know that in Europe they have no conventions to enforce Russian decisions, but sometimes we do it, and of course we do it in case of arbitration. But if I go in this decision a bit deeply, I understand that sometimes I have fear that it's against European principles. And I wanted to ask, what do you think? you have said about best practice and model rules, but what's going on in this sphere? Is it just so that we recognize Russian decision on individual basis, or can happen common rules about not recognizing? Thank you very much.
I'm not sure which country you are addressing. You talked about Russia. Russia has a regional cooperation within Eurasia, which is with the neighbor states. It's quite interesting to look at it. It's working well. It is very much elaborated also with IT cooperation. But of course, when it comes to third state constellation, we have all the problems you addressed, and that's still my concern here too, that we need to overcome the situation and in a flexible way. However, Russia at the moment is of course a very problematic situation, as the European Convention of Human Rights has been left, and therefore the European minimum standards do not longer apply. And what will be the consequence? Of course, an increase also of application of public policy clauses, and a going down of, let's say, judicial cooperation, which had functioned to some extent before the war in the Ukraine. There was one very interesting judgment in the Netherlands concerning the recognition of a Russian judgment, and the autonomous law of the Netherlands started from reciprocity, but the courts took the initiatives, arguing also with the case law of the European Court of Human Rights, to change via case law the situation of the autonomous Dutch law on the recognition of judgments coming from third states, so that finally this was a way forward. This would for me be an example of a very good practice. So I see your point. It's a difficult situation, and what is important here finally is of course not to forget human rights. Yeah? Behind a foreign judgment to be recognized, there is also a human right of a person who has a status. We should not only talk about money, but also family matters, for instance. And their courts should be very much aware of the situation. So we have human rights, of course, on both sides, and we need to look at procedural fairness regarding the proceedings in the state of origin. And if recognition does not operate, we have to look for subsidiary solution, which might also be facilitating access to justice, for instance, legal aid, representation, an active role of the judge to assist a vulnerable party. Thank you.
Thank you. And I think I would like to wrap up this panel by offering our overview speaker an opportunity for a brief closing remark.
Very shortly, this question has been debated on what instruments we use. I understand model laws. This is an old debate in the conference, in the Hague Conference of Private International Law. It was at the beginning of when the United States joined the conference. That was the debate. And the United States wanted only to have model laws. But the fact is that on certain issues it may work. And what we do as the Institute, for instance, we gave models, guidelines to follow, so that's fine. But when you have a need of a bilateral cooperation, in a way, a judgment to be recognized in other states, I think the convention is the only way. It does work otherwise. Just giving a model is not enough. That's my personal view. I mean, when you have to give, tell people how to conclude a contract, for instance, then you can have a model, and it works. But otherwise, it's not. When two states are concerned, it doesn't work.
I suspect that this conversation will be continuing after, yes. So thank you very much, this whole panel.
Merci beaucoup.
Thank you. Thank you very much. Of course, it's always a challenge to stick to the schedule. You did so. It was extremely interesting, and the written contributions are equally so. So this brings us to the end of our first day of the colloquium. We shall continue tomorrow on time, please. I will be in front of the door 10 minutes beforehand, calling everyone so that we start on time. Many thanks for your attention. Thank you for your contributions.